JBN, we keep you informed. Stepdad shot dead after hitting stepson. Biological father on the run. A Westmoreland man was shot and killed by two attackers on Saturday, March 7, after reportedly hitting his 3-year-old stepson. One of the suspects is the child's biological father. The man has been identified as 22-year-old security guard Owen Gardner of a Dallin Street, Savlamar, Westmoreland address, and Kensington, Welcome Hall, St James. He was reportedly in a common law relationship with the 3-year-old child's mother. Reports are that he was at home Saturday with the mother and her children when he reportedly hit the 3-year-old in the chest with an object. After a complaint was made to another resident, two men went to Gardner's house and he was shot in the chest during a dispute. He was taken to the hospital where he died while undergoing treatment. The police have launched a manhunt for the two men. Teen buried alive on construction site. A teenager who was accidentally buried alive while on a construction site in Granville, St James last Friday, was pronounced dead after he was rushed to the Cornwall Regional Hospital. The deceased has been identified as 19-year-old Novel Robinson, otherwise called Robbery, a laborer of Salt Spring, also in St James. Reports by the Granville police are that about 3:15 p.m., Robinson was among a group of workers carrying out construction work with Wiccan Construction Company at the Estuary Housing Scheme in Granville. Robinson was reportedly cleaning up a section of the site when the earth loosened and collapsed underneath him. He fell in the hole and was covered up by a pile of rocks and dirt which caved in on top of him. Other workers on the construction site raised the alarm and an attempt was made to remove him. The rescue team had to take its time to try to remove the debris from the hole without causing further injuries to Robinson. Robinson was rushed to the hospital after being taken from the hole, but was pronounced dead. One worker who did not wish to give his name said that he is still shaken up with the entire incident. "Me work on a lot of construction site, and it's the first time I ever see something like this happen," he said. "Me feel it in a way everywhere, for know so the youth so young and lose him life just like that. Everybody frightened when the place collapsed with him, but it's like we even more frightened when we try to dig him up." The worker said that he heard of persons dying in strange ways, but did not believe he would live to witness it. St James and Trelawny men charged with robbery. 3 men from St James and Trelawny are facing robbery charges stemming from separate incident on New Year's Day and February 20. One of the men is 19-year-old Patrick Williams, who is also known as Neil, a waiter from retirement Granville in St James. He is facing a charge of robbery with aggravation after he and another man allegedly held up a man at knife point, bounded him and robbed him of his mobile phone and $50,000. The victim was left in an abandoned building. The incident reportedly happened late afternoon on New Year's Day. However, it is not clear where the incident took place. He was charged after he was positively identified as one of the men during an identification parade. In Trelawny, 26-year-old Orlando Daly, also known as Sir, and the 24-year-old Oswald Johnson, known as Vaughan, both of racecourse in the parish capital Falmouth, were charged with 1 count each of shop breaking with intent. It is alleged that about 4 a.m. on February 20, both men broke into a business establishment. Their images were caught by a security camera. They were positively identified during an identification parade and charged. "We are coming for you," angry police fed boss warns killers of cop's mom. Chairman of the Police Federation, Sergeant Patriaro, has criticized what he termed the apparent apathy of Jamaicans to violent crime as he addressed mourners at the funeral of a cop's mom who was brutally murdered last month. Latita Francis was slain on Thursday, February 6, at her shop in Old Harbour Glades, St. Catherine. "Today we are angry, not only because of the way Miss Francis was taken from us, but because of the silence. Angry because our country has become so nonchalant in the face of barbaric actions which threaten our very sovereignty," Rose said. Rowe lamented that police personnel and their families were not insulated from gangland-style killings. Addressing a capacity congregation at the Old Harbor Seventh-day Adventist Church, the Police Federation chief delivered a call to action to hunt down criminals in the country and urged citizens to work with the police in apprehending them. He had a pithy message for violent criminals in Jamaica. "We are coming for you. Once you have touched one of us, you have touched all of us," Rose said. The Thanksgiving service had greater poignance because it was held on International Women's Day, a point that did not miss the attention of Police Commissioner Major General Anthony Anderson. This is a day when we should be celebrating a woman, celebrating the protection of women, and more importantly, where we recognize the sacredness of being a mother. "These are important things in creating the kind of society that we want," he said. Anderson declared that the country owed a debt to Francis's family that could never be repaid, stressing that no police officer should have to bear the burden from those carrying out cowardly acts on their families. Fitz Jackson, opposition spokesman on national security, in condemning the assault on a woman more popularly known as Miss Nancy, said that the deadly shooting was an attack on all. "We are all in it together. There is no government. There is no opposition. There is just one Jamaica when it comes to protecting our citizens," he said, adding that what has happened to Francis was that criminals are not only targeting law enforcement officers but their family. Jackson said that law enforcement officers should not bear the burden of worrying about their family when they were on the front line of the battle against crime and violence. They must have the assurance that the entire country is behind them, he said. Transport Authority faces $6 million court judgment over missing car. The Transport Authority, TA, is turning up the barrel of an almost $6 million court judgment in relation to the actions of persons on its behalf over 9 years ago. The Court of Appeal recently lambasted persons employed by the authority for treating a motorist with scant regard in relation to a motor vehicle which was seized in February 2011, and to date, no explanation has been forthcoming as to the whereabouts of the vehicle. The court ordered the TA to pay close to $6 million with interest to the motorist Amy Bogle. Bogle filed a suit in the Supreme Court in 2015 to recover damages for the loss of her use of her Toyota Mark II motor car. According to the judgment that was written by Appeal Court Judge Justice Jennifer Straw, the allegations were that on 15 February 2011, a motor vehicle collision took place along Waltham Park Road in the parish of St Andrew, involving the respondents, Bogle's motor vehicle, and a motor vehicle owned by the appellant, the Transport Authority, and driven by an inspector employed to the appellant. After the collision, Bogle's motor vehicle was seized and placed on a record by the Transport Authority's servants or agents. A warning notice was then written at the scene for Bogle, indicating that she had been warned for prosecution for the offences of operating without a road license and having no public passenger vehicle PPV insurance in contravention of the Road Traffic Act. Additionally, written across the top of the notice were the words Linder's Road Pound. The respondent stated that she was subsequently served with 2 summonses on 23 February 2011, requiring her to attend court on 8 March 2011. These summonses were in respect of the use of the motor vehicle as a public passenger vehicle without a road license, in contravention of Section 61(1) of the Road Traffic Act, and without a policy of insurance in accordance with Section 4(1) of the Motor Vehicles Insurance Third-Party Risk Act, the written judgment said. Bogle made several court appearances before the Corporate Area Traffic Court, and on April 24, 2012, the matter was dismissed, as the prosecution offered no evidence in relation to the charges that were laid against the motorist. But she faced several hurdles thereafter in her efforts to get access to her vehicle. According to the appellant court judgment, it appears that an order was made for the respondent's vehicle to be released on bond on 8 March 2011, the very first date that she was before the traffic court. She reportedly went to 119 Maxwell Avenue, one of the offices of the appellant, and the pound at Linders Road, demanding answers about her vehicle, but no one could tell her where it could be found, the judgment informed. Bogle then filed a suit in the Supreme Court in 2015 to recover damages for the loss of use of her motor car. At the end of the trial, the presiding Supreme Court judge awarded Bogle for conversion, which included loss of use of the vehicle, in the sum of $10.4 million. She was also awarded $400,000 for the value of the motor vehicle. The TA later appealed the decision of the Supreme Court on 3 grounds, the first of which stated that the learned trial judge failed to give due consideration to the evidence before the court, which ought to have satisfied the court that the respondent had failed to provide all the elements required under the tort of conversion. But while the Court of Appeal disagreed with those arguments, it reduced the award that was granted to Bogle to approximately $5.9 million with interest at the rate of 3% from May 14, 2012, the date of service of claim forms, to the date of judgment. In giving reasons for the decision, Justice Jennifer Straw, who wrote on behalf of Justices Hilary Phillips and David Fraser, who were members of the panel which heard the appeal hearing, said the Supreme Court judge was correct in concluding that the loss of the use of vehicle was proved. However, the Supreme Court judge was said to have erred in awarding damages of over $10 million due to the calculations he made. Based on the evidence, the learned judge cannot be faulted for concluding that the tort of conversion had been proved by the respondent Bogle against the appellant Transport Authority. The trial judge was also correct in his conclusion that the consequential loss was proved. However, the proper sum to be awarded is in the amount of $5,965,714.29, wrote Justice Straw. The amount of $400,000, which was awarded for the value of the motor vehicle and which was not contested by the appellant, will remain, she added. The appeal court chided the servants of the TA for not providing an account for the whereabouts of Bogle's vehicle even at the time of the hearing of the appeal. The egregious conduct of the servants of the appellant Transport Authority gave rise to these proceedings. This court has found that the respondent Bogle had been treated with scant regard, and this continued even up to the hearing of the appeal, as no explanation or acknowledgement of responsibility has been given to the respondent in relation to her vehicle, the judgment indicated. No cost was awarded to the TA, despite having had some success in the appeal. Although the appellant has experienced some measure of success on its appeal, in the interests of justice, it should not be awarded any cost. In the circumstances, the respondent should be entitled to all of her costs, the Court of Appeal concluded. JBN, we keep you informed. Please remember to subscribe, like, share, leave us a comment, and click the notification bell to receive our daily news items.